Co-owning property, it sounds like a great idea, right up until the moment it isn't. So what happens when one person is ready to sell and the other refuses to budge? It's a really messy and honestly a super common problem. For a long time, the law on this was clunky, confusing, and just plain unfair. So how did we get from the law basically seeing your home as a cash machine to recognizing it as, well, a home? And what does it all mean when you're stuck in a legal deadlock? Let's dive in and break it down.
So, you're at a total stalemate. You want to sell, they want to stay. It feels completely impossible, right? But there is a specific law designed to cut right through that kind of chaos. It's called the Trusts of Land and Appointment of Trustees Act 1996. Bit of a mouthful, so everyone just calls it TLATA. And it's basically the legal toolkit for when co-owners just cannot see eye to eye.
All right, here's the game plan for this explainer. First, we're going to look at the bizarre old system, the trust for sale, just so you can see why things desperately needed to change. Then we'll get into the modern solution, TLATA 1996. We'll unpack the key tools the court uses, that's sections 14 and 15, and we'll look at the exact checklist a judge has to follow. And finally, we'll cover the one situation that pretty much throws the entire rulebook out the window. Bankruptcy. That's when the stakes get so much higher.
Okay, so to really understand why TLATA is such a big deal, we need to take a quick trip back in time. We've got to see the deeply flawed, kind of weird system it replaced. It was a legal framework that just wasn't built for how people actually live.
So, before 1996, all co-owned land was held under what was called a trust for sale. And here's the absolutely wild part. Under this system, the law automatically put a legal duty on the owners to sell the property. Your home, the place you live, was legally viewed not as a home but as an investment that was just waiting to be turned into cash.
And believe it or not, it gets even stranger with something called the doctrine of conversion. Just think about it this way. It was like you didn't own a piece of the house. You just owned a claim on the money you'd get when the house was eventually sold. This crazy legal idea meant your interest wasn't in the actual bricks and mortar. It was only in the cash. It meant, legally speaking, you didn't even have a right to live in your own home. Nuts, right? Unsurprisingly, this whole system was eventually called out for what it was, completely anachronistic, a relic of a past that treated homes like they were stocks and shares and totally ignored the real, emotional, and practical side of owning a home. The law desperately needed a reality check. And that reality check finally arrived in 1996. The Trusts of Land and Appointment of Trustees Act, TLATA, came in, swept away that entire outdated system, and replaced it with something that actually makes sense in the modern world. And I'm not exaggerating. For property law, this was a seismic shift. The fundamental way the law thought about co-owned property was turned completely on its head. So TLATA got rid of the old trust for sale and brought in the new trust of land. This was a massive deal. That automatic duty to sell, gone. That bizarre doctrine of conversion, abolished. For the very first time, the law officially said that a co-owner's interest is in the land itself, in the actual home. This finally gave owners real rights, like the right to actually live in their own property.
Okay, so the philosophy is better, which is great, but how does this actually help solve a real-world fight? Well, TLTA gives the courts a clear, practical toolkit, and it's all built around two key sections, sections 14 and 15.
Think of Section 14 as the key that unlocks the courthouse door. It's incredibly powerful because it's so broad. It says that any person with an interest in the property, a co-owner, a bank with a mortgage, literally anyone involved can go to court and ask for an order. The court can then make a decision on pretty much anything, including the big one, whether or not to force the sale. But once you're in court, how does a judge actually make the call? They don't just flip a coin. Section 15 of TLATA gives them a very specific checklist of factors they have to consider. This gives them a clear roadmap for making what's often a really tough, emotional decision. And this is that checklist. The court has to weigh four main things. First, what did the people who set up the ownership originally intend for the property? Second, what's its purpose now? Is it a family home, an investment? Third, what about any kids living there? Their welfare is key. And finally, what about any creditors, like the bank that holds the mortgage? The judge has to balance all of these to try and find a fair outcome. So let's start with those intentions. The court basically asks, why was this property bought in the first place? A great case for this is Barkley versus Barkley. Here, an owner's will was crystal clear. When he died, the property was to be sold and the money split. One of the beneficiaries was living there and wanted to stay, but the court said no. The creator's intention to sell was spelled out, and that took priority.
Next up is the property's current purpose. Why is it being held right now? The cases here really show how this works. In Jones v. Challenger, the property was a marital home. Simple enough. But once the couple got divorced, that purpose was over, so the court ordered a sale. But then you compare that to a case like Chun v. Ho, where a sale was put on hold. Why? Because a key purpose was to provide a home for a student to finish her studies, and that purpose was still very much ongoing.
The third factor is a really important one: the welfare of any kids living in the house. In a case called Re Evers Trust, the parents had split up, but the court refused to order an immediate sale. It decided that a primary purpose of the trust was still happening: to provide a stable home for their children. Now, this isn't an automatic trump card, but the children's needs have to be weighed very carefully in the balance.
And that brings us to the final factor: secured creditors. What about the bank? While TLATA says all the factors get weighed, cases like Bank of Ireland v. Bell have made it pretty clear that a creditor's interest is, and I'm quoting here, a very powerful consideration. So in a straight-up fight between a co-owner who wants to stay and a creditor who wants to get paid, the creditor's request to sell is almost always going to win out in the end. So we've been talking about disputes between co-owners or maybe with a lender. But everything we've just covered, it gets pretty much tossed out the window when one of the co-owners is declared bankrupt. This is a whole different ballgame, with a completely different set of rules. And this is where things get really stark. In a normal dispute, the court uses that balanced four-part checklist from Section 15 of TLATA. But in bankruptcy, a totally different law, the Insolvency Act, kicks in, and the focus shifts dramatically. Suddenly, the interests of the creditors are number one, and crucially, the personal needs of the bankrupt co-owner, they are completely ignored by the court. And there is a critical deadline. When the trustee in bankruptcy applies to sell the home, the court might grant a short delay. But after 1 year, it's like a switch is flipped. The law automatically assumes that the creditor's interests outweigh almost everything else. At that point, a sale becomes almost unavoidable. The only way to stop a sale after that 1-year mark is to prove exceptional circumstances. And let me tell you, the courts have set this bar incredibly high. A famous case, Recitro, made it clear that the normal sad things that happen when you lose a home, like family disruption or kids having to move schools, are not exceptional. They're just seen as the unfortunate, expected consequences of debt. So what in the world actually counts as exceptional? Well, the cases all point to extreme personal hardship, almost always linked to a serious illness or a severe disability. You see it in cases like Ravi Raval, where a spouse had paranoid schizophrenia, or Rob Bremer, where the bankrupt person themselves had terminal cancer. These are the kinds of devastating situations that might be enough to justify making creditors wait a little longer for their money. This quote from the case, Dean versus Stout, just perfectly captures the court's tough stance on this. The underlying message is simple: debts have to be paid. The consequences are melancholy, sure, but they're seen as the direct result of that debt. Legally, creditors have a right to get their money back from the bankrupt's assets, and that includes their share of the family home.
So, in the end, TLATA 1996 gives us this balanced modern way to solve disputes between co-owners, finally recognizing a house as a home. But when bankruptcy crashes the party, the Insolvency Act takes charge with a much colder, creditor-first approach. It leaves us with this fundamental, really difficult question: how, as a society, should we balance the deep emotional value of a family's home against the cold, hard right of a creditor to be paid? The law has drawn its lines, but that's a debate that is far from over.